Hello and welcome to the Sisters for Fitness Wellness Show. I'm Stephanie Gaines Bryant. Our guest today is Suren Adams, and she's an attorney, and we're talking about something we've never talked about before. We're talking about estate planning, and the name of your book is Leaving a Legacy Instead of a Mess, Estate Planning with Living Trusts.
Yes.
And we're talking about especially estate planning for women. Welcome.
Yes. Thank you so much for having me, Stephanie.
Now, people are going to say, well, I'm only 21, I'm only 30, I'm only 40. Why should I think about estate planning? Who wants to think about that?
Well, a lot of people put off estate planning. It's obviously not everyone's favorite topic. But in my view, really, if you're over 18, you should definitely be thinking about an estate plan. Even as we send our kids off to college, we should have a durable power of attorney on file for them, an advanced healthcare directive, so that if anything happens, you have the authority to handle finances for them, handle medical decisions for them, and to know what their wishes are for those things.
What is the difference between having a will and having a trust?
Huge difference. So a will still means that you're going through probate, and a lot of people are not aware of that. They think that, oh, I have a will, so everything should be fine. It doesn't avoid probate. It actually means that you're going through probate and you're just letting the court know what your wishes are, but they still have to supervise the distribution of your assets. If you have a trust, you basically retitle all of your assets into the name of the trust that you control. The trust completely avoids probate, and it has a lot of other benefits as well.
So you can't have either or you can't have both?
Usually if you have a trust, you'll also have a will as a backup in case there are any assets you've forgotten to put into your trust. But if you just have a will, you're going through probate.
What should that will include?
Well, your will should include your burial versus cremation wishes. If you have minor children, it should have who the guardian of your children would be. If you're doing a trust, your will essentially would say, if anything has to go through probate, put that into my trust after the probate. So it's basically called a pour-over will because it pours into your trust. Your trust, on the other hand, should have all of the distribution instructions that you want for your beneficiaries. So you can be really creative, you can be really specific with trusts. You can say things like, I have minor kids, so I don't want them to inherit everything at 18, which is what would happen if something happened to you and you passed away while your kids were minors. Everything would be held in a custodial account and they would get everything at 18, which is the worst possible time to inherit a lump sum of money.
Yes.
So in a trust, you can say instead of that, I want assets distributed to them for their health, their education, maintenance and support, and then when, for example, they're 25, then they can have maybe a third, and then at 30, another third, at 35, another third, or you can pick whatever ages you want, whatever percentages you want. You can do things like asking for or requiring that they meet with a financial advisor before getting a lump sum, or going through a Dave Ramsey course or something like that, so they know what to do when they inherit these lump sums of money.
How do you decide who's in charge of your estate?
That's a very important decision to make. You have to pick someone for your trustee role that you trust. It's built into the name. It has to be someone that you trust to handle affairs the way you would. Somebody ideally who's a little bit financially savvy, and if they're not, they would at least be wise enough to know when to hire a professional to help them. But more than anything, somebody you trust.
How about in situations where when you wrote the will or you did the trust that you were married or you weren't married, you were single, for example. Years later you get married and you just leave things the way they've always been and you pass away. What happens with the spouse or what happens with the children?
Right.
Who has the ultimate say?
Whatever you've left in your documents. So that's really the goal with a good estate plan. It's future thinking. So you're going to think about what happens if I'm single now and I get married in the future, will I want to amend things? You really should look at your estate plan at least every 1 to 3 years after you've created it so that you can keep it up to date. If you were married when you created your estate plan, usually things would remain the same because you have built-in provisions that if something happens to me, my spouse takes over. If something happens to my spouse, this other person takes over. But if you're single when you initially create your plan and you then get married, you'll probably want to update your plan. You don't have to, because you may still want the same things to happen. But if you do want that change, you'll need to update the estate plan.
What about those deathbed requests? Well, mom said on her deathbed that I get the car, but that's not written anywhere.
Then it's not legally binding. And that's the problem. It happens all the time. And sometimes people will say one thing to one child, another thing to another child, and it just causes this huge mess at the point where you have to probate an estate like that, because you have family members fighting over something that doesn't need to be fought over. If you're specific, you have a written, legally binding document in place spelling out what your wishes are.
What should people put in the document? Can you put things like jewelry in the document? What you want, pets? What are some of the things, the most important things?
The most important things would be what percentages you want to give to whom. You can put things like, I want this particular piece of jewelry to go to someone in particular. Oftentimes when we create a trust estate plan, we usually do a memorandum at the end that actually will spell out things like jewelry, fine art, furniture, your china. If you want someone in particular to get those items, you can put that in the memorandum so that if you change it, or if the item breaks, or you give it early, you don't have to change your entire trust. You can change the memorandum much easier. If you put it within the trust, you can still amend your trust and change those types of things later. But the key thing would be, after all those little things are given away, how do you want the most important parts, the larger parts of your assets, distributed? Do you want 10% going to one child and 50% going to another child, 40% going to another? How do you want it distributed? Do you want to include charitable institutions as beneficiaries of your estate? And then who do you want to be managing those assets?
When you go into probate, is it a long time consuming thing, and what are the expenses involved?
Yeah, probate is time consuming. For a regular estate, the minimum time in Maryland is about 7 months. Most estates take about a year to administer. So if you can avoid probate, you should. The costs are also an issue. For example, if you have a $500,000 estate, which may seem like a high number, but it's really not in this area, especially with home prices the way they are. Your estate is most likely going to cost about $20,000 to administer, and that's money that's not going to your beneficiaries. That could be if you had a different type of estate plan, if you had a trust estate plan. So the probate cost, the expense, it's also a public process.
What does that mean?
Right, a lot of people are not aware of this. So you can go to the Register of Wills and ask for an estate file. Predatory individuals do this. Predatory individuals also will go and file claims in an estate, claiming that they are owed money from the person who passed away. And all of these are things that can end up eating away at what you're meaning your beneficiaries to get. Also things like basically filing illegal claims in an estate. All of these things that you then have to deal with and discover whether or not this is an accurate claim. They can find out who's inheriting, when they're inheriting, the amount they're inheriting, their contact information. It's all public information. So when we think about Aretha Franklin, Prince, all these people who haven't created an estate plan, and all of a sudden we know all their business, that's why, because it's now public.
And you would think that people with that amount of income would have thought ahead.
Yeah, it's really unfortunate. I get a little angry when I hear somebody that has that kind of wealth and really has legal advice in their life isn't really getting a proper estate plan put in place, because it's all of that is completely avoidable. You can have a plan that's private, you can have a plan that you share with only specific individuals, and it all can be handled outside of court. So why not do that if you can? And it just takes a little bit of planning ahead of time.
And we talked about some of the negatives of going into probate. Are there positives?
Well, the court is supervising the distribution of the assets, so you have kind of that check and balance. But again, if you have picked the person that you know you trust to do that instead, you really don't need the court involved. It just adds that layer of additional documents that have to be filed, deadlines, the expense, the time delay. So
Is it something that you definitely need an attorney to do, or is it something that you can do from looking online when it comes to putting together a trust?
Putting together a trust, no, I would not recommend doing it on your own. You don't know what you don't know. So
And what don't we know?
There's so many different details that the layperson would not know. And I think we're all really tempted nowadays to do that. We diagnose ourselves online.
Yes!
We go on these,
WebMD is my friend. No.
We Google everything, so it's easily accessible. So we assume because it's out there and accessible that we can do it. But when are you going to find out that there's this big gaping hole in your estate plan and it isn't doing what you want it to do when it's too late? So when you're talking about your estate and you're trying to protect assets for the next generation, you're trying to make things smooth so that people who are mourning you are not in the midst of that process also dealing with paperwork and fixing things that you meant to do but didn't do quite right. You don't want that to be the legacy you're leaving. You want to leave a very clean, well thought out plan that addresses all the things that you can think of and maybe you can't think of because you don't know what to think of, but your attorney would know. So hiring a legal professional to prepare an estate plan is a very well spent fee because you are making sure that it's taken care of properly.
We talked about the age thing and how people will say, well, I'm too young to think about that. Mm-hmm. How about the people who say, I don't have that much money, mm-hmm. so why should I think about that? I'm not going to be, you know, I don't
not
have,
a Rockefeller,
exactly. I'm making ends meet, you know, I'm doing what I'm supposed to do to support myself and my family, mm-hmm. but I'm not going to be leaving behind $1 million. Mm-hmm.
My basic criteria, if you own a home or if you have minor children, you should have a trust estate plan. If you don't even own a home, you should have some sort of an estate plan, especially if you have minor children. You need to be designating who is going to be the guardian of that child if something happens to your children. You don't want family members arguing about something like that. You need to be the one making that decision. Oftentimes the loudest, bossiest person in your family ends up taking over the situation and getting what they think should be happening.
And they might not be the most knowledgeable.
They might not be the most knowledgeable. They might not be the person you want in charge of decision making. You need to be the one making the decisions, and it needs to be your thought behind it, who you've chosen, what reason. You can give instructions in your estate planning documents for the people that you're leaving in charge of things. So it's just one of those things why when we plan for so much in our life, we have insurance, we have health insurance, life insurance, we insure our cars, all of these protections we build in around our lives, and yet we assume that everything is going to happen the way we think it's going to happen or want it to happen when we're not there. And that's the riskiest time there is when you're not there to make sure it's happening.
We've got a lot of adults who are in that sandwich generation where you're
yes.
raising your kids and also taking care of your parents. Mm-hmm. What if you've got a parent who's got dementia, mm-hmm. who hasn't, you know, left behind instructions? Mm-hmm. That can become a very critical situation.
It is, and it's one of those tough situations to deal with all the way around. It's tough even for the legal professional who wants to put in a plan for this person, but you have to have legal capacity in order to create an estate plan. So the sooner you do it, the better. And the diagnosis of dementia does not mean that you don't have any capacity whatsoever to create a plan. It depends on how far along that disease has progressed. Alzheimer's and dementia, all of these types of things.
Speaking of medical issues, what about medical requests? Like mm-hmm. if you're on life support and you don't want to remain on life support, mm-hmm. you just want to go. Mm-hmm. Can you make those type of requests?
Definitely. You do that in a living will. That's part of your advanced healthcare directive. So the advanced healthcare directive in our office, we do kind of a 4-part document. We do a HIPAA authorization so that your agents that you're naming to handle medical decisions can get access to medical records. Say, for example, if there's a medical malpractice issue, and that document actually survives your death so that if something happens, they can still get those medical records. Then we also do the advanced directive itself. So that's naming the agents who handle your medical decisions if you're unable to. Then we do a living will, which specifies what your end-of-life wishes are. So if you're in a terminal condition, a vegetative state, end-stage condition, situations where any additional medical treatment isn't going to help you to recover, you can state, yes, I want to receive all available artificial medical treatment. Or you can say, no, I just want to die naturally. I don't want any artificial medical treatment whatsoever. Or you can say, I just want food and water artificially. So you can specify time periods that you would want that kind of care, so that, and really it's a gift to your family members because you've spelled out exactly what you want. They're not guessing, they're not left with guilt at any decision that they've made and not knowing whether or not that's what you wanted to have done. You spell it out. So you kind of save them that emotional turmoil at an already emotional time.
What can be very intimidating when dealing with an attorney in a living will or a trust? You speak another language. What are some of the terms that people should be familiar with? To make yourself familiar with?
What we actually do when somebody sets up an appointment with our office to come in to do an estate plan, we send them frequently asked questions and terms, because it's like another language. And really what it boils down to, we'll explain whatever you need to have explained to you, but we really want to hear from our client. What are your wishes? What are your concerns? And we then translate that into our legal language. So it isn't really, it's almost not even necessary for you to really understand those legal terms when you find an attorney that you trust. So you want to be able to be speaking with somebody who gets where you're wanting to go with this plan, gets what your wishes are, understands your family dynamic, the things you're trying to protect against, trying to guard against, the things you want your family to be doing with the finances, how you want assets spent, all of those types of details. So we spend a lot of time in our consultation talking about your family structure and what your goals are with an estate plan. And then we then translate it into that language.
How are bills handled? Bills that are left behind, how is that handled?
It depends on the type of plan you have. So if you have just a will and you're going through that probate process, again, anyone can file a claim in your estate, and you then, your executor or personal representative, different names but same role, they have to then figure out who has a valid claim. So they then pay those claims out of the estate if it's a liquid estate, if there's enough money in the estate to pay the bills. With a trust estate, it's actually kind of a switch, because the trust owns all of your assets, none of your debt. Your debt is part of your probate estate. So you're actually also eliminating some of that liability. Most of the time when you have a trust plan, they're liquid assets enough to pay off debt, so most people do that anyway. But the legal liability to do that is a little bit different with a trust plan.
What has been a successful trust plan where the people walk away, the family members walk away, or have you ever had a situation where everybody walks away happy? There's always going to be some family member who feels like they got less, and such got too much, but to safeguard that is why you should go ahead and make a plan.
Exactly. Most of the families that we deal with end up leaving things pretty equally, and if they don't, it's for a particular reason, like they've gifted things ahead of time to one particular child. So, and if that happens, we usually kind of spell it out in the plan so that there's no misunderstanding later on, kind of thinking down the road, what are issues that are going to be coming up when this is actually being administered. But for the most part, people will leave for like their kids equal shares and things, and if they don't, it's for a particular reason, and most of the time the family knows those reasons. So oftentimes pretty much all of our clients walk out, and I think a lot of people don't realize the stress that they're carrying around when they know they need to prepare a plan, but they don't, and they keep putting it off. Because when our clients leave, they're like, I'm so glad we got this done. They breathe a sigh of relief, and it's kind of a celebratory time, even though you're dealing with kind of a rough subject. But the feeling to get everything in order and to know that it's going to be taken care of in the way that you want it to be taken care of, the way that's going to protect your family, that you're really leaving this legacy for the next generation that they can build on, so we're not all starting over from scratch every generation. It really is a good feeling.
What are the questions that you should be asking your attorney? And another question, after answering that, should it be a family thing? Should the family go in together, or should it be whoever that person is?
It really depends on the family dynamic. So that is really the personal choice of our client. Some clients want their entire family involved in the process. They want everyone knowing all the details of the plan ahead of time. I kind of prefer that because then there's no mystery in the plan. I think a lot of times family members start getting angry or bitter about things when they don't know what's going on. So I kind of prefer the open plan, but some people don't want, they've always been private their entire life, they want to remain private, and that's perfectly fine. That's part of the benefit of a trust plan. No one else has to know about it until either the trustee or successor trustee steps in. They obviously need to know what to do with your plan, and the beneficiary is receiving those assets. Otherwise, you don't have to share it with anyone if you don't want to.
And you just mentioned that you don't need to know legal speak. If you get the right attorney, then you don't need to know what this word means. What's the difference between a living trust and who's the executor? Yeah, who's this person and who's that person? How do you ask those right questions?
Yeah, it's really, here's the question that I ask when I'm in a consultation. Who do you trust to handle your finances if you can't? Who do you trust to handle your medical decisions if you can't? And then we get a backup person for that person. If that person can't serve, who would be the backup that you would want to serve instead? And these are really the key questions. We don't say, who do you want your successor trustee to be? Because most people are not aware of what that's even talking about. Who do you want your personal representative to be? The durable power of attorney agent, your advanced healthcare directive? Those questions are the legal speak. We're putting those things into the actual documents. But what we need to know, who do you trust to handle finances? Who do you trust to handle medical decisions if you can't do those decisions? And then really the meat of the plan then comes out to how do you want things distributed to the people that you want to leave your things to?
You mentioned earlier in our discussion about leaving things to children and how you can split that up. An 18-year-old is not, I know I have a couple of 18-year-olds, but an 18,
think back to when you were 18,
yes.
I was going to Jamaica if you were leaving me, any major amount of money.
Exactly. You talked about how you can break that up into sensible increments where you can get this amount this time, this amount the other time, this amount the other. You're not handing an 18-year-old an ungodly amount of money to deal with.
And when we think about life insurance and the amounts that we put in life insurance that we should be putting in life insurance, and if something, God forbid, happens to, for example, both spouses, and this child is inheriting $1 million at 18, they're not spending that on tuition. They're not spending that on books. They're not saving that for the house that they're going to buy, in 5 years. But you can say in your plan, you're going to be saving this, and if you're buying a house, yes, you can have a chunk. If you're getting married, you can have a chunk. If you're starting a business, you can have a chunk, and you can say what percentage that can be, or you can just say leave it open to your successor trustee to make that decision, the person that you're leaving to handle the decisions. But you always have built in there that they can have access, the trustee would have access to those funds to take care of your children. So health, education, maintenance and support, that's already built in. And then you can do things like, for example, if you have a child who maybe they're an artist and they're not going to have a good retirement, but you want to encourage them to still pursue what they're doing without having this kind of crutch of a trust. You can say things like, hold this in trust until their retirement age, and you can state what the retirement age would be. Or if you have children that have any kind of chemical dependencies or bad habits, you can actually have drug tests be part of what the trust involves. And
there are so many creative.
You can be so creative. I love planning with a trust because really you get into the family dynamic and you can plan for all sorts of things. It's actually fun.
What is the most frequently asked question for people?
I think the issue between wills and trust. What's the difference and why have a trust instead of a will? That's usually the biggest question that we get, which I'm glad people are asking that question because so many people don't understand the difference.
They don't, and you think I have a will and that solves everything, and it absolutely doesn't.
It doesn't.
And you talked about all of the risks of going into probate. Another thing you mentioned earlier is you should look at this information every couple of years. You shouldn't just do it and then not look at it for 10 years. Life changes. The people in your lives change. Circumstances happen.
Yeah. So as those things happen, people move, relationships change, children mature. So all of those life dynamics that are going on, you need to be thinking about that with your plan in mind. And who's going to be thinking about that on the day-to-day basis? We have lives. So if we in our firm have an annual maintenance plan, if you want to set that up where we actually have a trigger to remind you annually on the anniversary of your the signing of your estate plan, we will send a synopsis basically to you saying, here are all the agents you've named, their contact information. Is this still correct? Here are the beneficiaries you've named. Here's how you're distributing things. Is this still correct? And we also let you know if there are any changes in the law that require a change in your plan.
How does that affect things?
So even just this past year, there was a change in the estate tax. So for federal estate tax, it's gone up the threshold to 11.2 million, and the estate tax is hefty. It's 40%. So you want to know where your estate is in terms of the size of the estate so that you know whether or not you're subject to any of these estate taxes. In Maryland, the threshold is 4 million. So, and the percentage is 16%. So
what does that mean? Because
right.
Yeah, what does that mean?
So after your passing, the size of your estate, and that's life insurance, your equity in your home, personal property, stocks, bonds, all of those things are added in together for federal estate tax purposes. And if the size of that estate is over a certain amount, then you're assessed estate taxes. Your estate has to pay 40%.
That is huge.
It's huge, but it's for larger estates now because the law just changed. And things like that happen all the time. They change the estate tax rules. Maryland has a Maryland Trust Act now that was recently enacted. We have a Maryland statutory power of attorney. So all of these things are things that we update on an annual basis with our clients who are in our maintenance plan. We'll send them the latest version of the documents. You want the state-of-the-art documents because you want the greatest protection.
Absolutely. It has been an absolute pleasure.
Mine as well.
I've learned a lot.
Thank you so much for having me.
And the name of your book, once more, is Leaving a Legacy Instead of a Mess,
Yes.
because I'm sure everybody has seen a situation where a loved one has passed and the siblings or the relatives are just fighting like cats and dogs.
It's
people who
unfortunate.
love each other dearly
Yeah.
are at each other's throats, and we don't want
No,
that.
we don't want that.
And it's estate planning with Living Trust, and you're Suren Adams.
Yes.
Suren, thank you so much for joining us.
Thank you so much for having me.
You've been watching the Sisters for Fitness Wellness Show. I'm Stephanie Gaines Bryant, and of course we're going to put your information in the credits as far as your email address and name of the book again, and the way people can contact you.
Great. Thank you so much.
You've been watching the Sisters for Fitness Wellness Show. I'm Stephanie Gaines Bryant. Have a great day.